We're speaking today with Clayton Ruby, one of Canada's most vocal lawyers and activists specializing in constitutional and criminal law and civil rights. So first I just wanted to know a bit about you, since you dedicate your life to these types of cases, to defending the underprivileged and those who are discriminated against. I'm just curious about your own personal inspiration that got you to dedicate so much of all of your career to this.
You know, I don't know that there ever was any particular or overriding inspiration. I was raised by my parents that if you saw something wrong, you took steps to make it right. Mm-hmm. And we live in a world where there's a great deal that can be done to make it a better place and a fairer place, and I thought that was my obligation. But it wasn't anything more than that, it's my obligation.
It just felt logical for you to be dedicating all this time and effort to that.
There are times when it does not feel the least bit logical, it feels mad, but it's an obligation.
Yeah, okay. The Charter.
I remember the Charter slightly.
Slightly, a little bit. You use it a lot.
Yeah.
You refer to it a lot. You leverage it a lot. Curious, I mean, it came out in 1982, so it's been a while that we've been using it. How has, if I ask you a very general question, but you can be more specific, how has the Charter impacted the way we, practice law and defend the accused and help the minorities? Is there something that would have been impossible, let's say pre-1982, that now has become incredibly possible and viable, and that you use to your utmost?
The practice of law has been turned upside down. In 1982, things became real in a way they never had been. Let me give you an example. You had somebody who had been charged, and the police had beaten them up in order to get physical evidence, fingerprint evidence as a result of the beating. The police had entrapped him, treated him unfairly, blackmailed his wife in order to get her to pressure him. You would have looked at that case and said, this is really unfair. This is contrary to what we believe as Canadians. And if you went to court and said any of those things, they laughed at you because they were all irrelevant. Right. Would make no difference. If evidence was obtained illegally, so bad, it makes no difference. So all of a sudden, you could talk about what was real. You could make a difference in the outcome of the case by saying, let's talk about fairness. Let's talk about fundamental justice. Those were concepts that were not part of the legal lexicon. They were legal concepts always, but they didn't make any difference in Canadian law. And then all of a sudden, you could talk about real things. The police had no right to stop this demonstration. They were interfering with my client's speech. Before the Charter, you could stand up and say that, and they'd all be giggling because it made no difference.
Now it's taken seriously.
Now it is a fundamental principle, and it has the effect very often of stopping prosecutions in their tracks, if they're improper.
If they're improper. And I was looking back at some of the cases that you fought. The Askoff case, for example. How that fight for a right to a speedy trial for the accused and the impact that that case had on the cases that followed it. Is that one of your prouder moments? Because I do think that that is a huge problem that is still being grappled with in terms of getting speedy trials, moving forward with the Charter, 11B and that whole area. So is that something that really...
You focused on the exact issue. I think it was 10,000 people who were freed as a result of the Askoff decision. They've been kept in jail too long, they've been denied their right to a trial, they were languishing without ever anyone deciding whether they were guilty or innocent, and we decided that that was wrong, and it had to come to an end. And the Supreme Court of Canada made that quite clear. That was an important and and significant moment in Canadian legal history.
Mhm.
But what's happened since is that the Crowns have kept on going back to the judges and whining and pleading. Oh, this is a serious charge, you can't throw it out. Give us a little extension, be more liberal in the way you give us time to bring things to trial. Don't hold this against us. I know we didn't give disclosure for 4 months, but and it could have been done in 3 days, but nonetheless, don't hold it against us. Let's label that neutral time, and not count it against anyone. Wouldn't that be fair, Judge? And over the intervening years, the judges have accepted this. So that the fact is, the delays now are longer than Askoff.
Really? Okay.
It's impossible. It's a classic example of reform of the law through judicial decision being absolutely useless.
I see that as a challenge someone in your position faces. Even though the charter, in its intention perhaps, it had a lot of worthy goals and still does, that and other ways that it's interpreted and the way it's watered down in certain ways must be a challenge for you. And I'm wondering, what other challenges are you faced with, even though you have this wonderful charter, but what are the charter's challenges and the obstacles that you are dealing with? Is that the main one that you have to deal with, or is there other ones that...
It's not an uncommon problem. The old Soviet Union had a constitution that you would have died for. Mm-hmm. It guaranteed every right in the finest language. It would have made you proud, but it meant nothing, because in practice, the judges of the Soviet Union never enforced it in favor of a citizen against the state.
Right.
So we face a common problem, which is the power of the state, who point the judges to eventually persuade them that the state should have its way despite the language of the charter. And so some of the interpretations are quite twisted. You wouldn't be proud of them at all. And Askoff is a classic example of that. What do? You keep on fighting. If you look at the history of constitutional decision-making in, for example, the United States, mm-hmm. which has a long constitutional history and a similar in principle charter to ours, it's up and down. For years, the Dred Scott decision, justifying separate but equal and near slavery conditions in other contexts, was the law, and then people kept pushing and that got reversed, or legislation reversed it, or you see my point. That's what you do. You find out what's right and you fight for what's right. And it's like the struggle for gay equality. Yeah. We lost in the legislature. Horrible Bob Ray put this to a free vote. If you can imagine putting human rights to a free vote. He did that, and then he didn't whip his caucus, or wasn't able to whip his caucus, as the case may be, and equality was denied in Ontario. We kept on fighting. In that case, you leave the political arena and you go to the courts. And we won in the courts, as it turned out.
But does that stick in terms of setting a precedent, or can the courts then, like with the Askoff case, reevaluate it? So it's frustrating, I would imagine. But
it's frustrating, but it's an important reality that the struggle for justice does not end with a decision or a particular law.
How about the freedom of speech? You've made some interesting points about hate speech, and you actually said recently the only effective antidote to bad speech is good and thoughtful speech in a democracy. So you obviously don't believe in any sort of limitations on freedom of speech. That is in your...
Apart from the ordinary criminal law.
Okay.
I'm not talking about new stuff that you bring in that you label criminal law, but the traditional criminal law, you can't counsel the commission of an offense. You can't encourage someone to commit an offense. Those are already crimes. Mm-hmm. They're quite sufficient to protect us all. Okay. And conspiracy. Conspiracy is really wider than it ought to be, but it's, you conspire with somebody else to commit an unlawful act. Well, that's a huge chunk of behavior that's criminal already. And
so something like Bill C-51, that I'm sure you have an opinion on when it comes to the upholding or not upholding freedom of expression, freedom of speech. How do you see the law right now? What do you think? Well, it's hugely chilling because they're contemplating doing all this in secret. And most of it you'll never know about. And you won't be able to go to court and challenge it. So it's crucial that there's a challenge going on, and the Civil Liberties Association is doing that, and the journalism organizations are doing that. That's precisely what should be happening right now, and I'm proud of that going ahead. But provisions with a structure that is unconstitutional. For example, our Constitution is set up on the premise that the legislature makes the laws,
and the judges decide whether they meet constitutional standards, whether they're valid laws. That's a separation of function which makes sense, and the Constitution contemplates that separation exactly. The government's trying to get around that by saying, okay, we'll go to a judge and ask him to authorize the breaking of a law in light of a charter.
Right.
But we'll have no standards. We'll just let the judge do it as they see fit. And they can interpret the Constitution as they go along. Totally new model of the relationship in a democracy between the citizen, the government, and the courts. And I think unconstitutional and extremely dangerous.
They're not using notwithstanding clause for that.
Oh, no,
Okay.
they're not.
Okay.
Politically, the notwithstanding clause has been used only in Quebec and only on, I think, one occasion.
Okay. I was wondering about that because that could also pose a challenge for those.
It
of us.
could, and you worry about that.
Yeah.
When the charter was enacted, I was very worried about the notwithstanding clause, but its history has not been very bad.
Okay. And just wondering, what would you say, you've been doing this for a long time, what would you say are your proudest moments? If you can think of them.
I really don't think in those terms.
You don't at all? Things that you really think back, like the Askoff case and other attempts, efforts that you've made.
There are guys who do this. They walk around with their head with all their triumphs. Once I've done it, it's gone.
It's gone, it's done.
And that's really quite nice because it liberates you from all that, including your losses.
Yes.
Major losses. And you can move on to the next problem.
Okay, okay. So, no proudest moments. No proudest moments, but anything you can say about, let's say we look at the proudest moment for the charter. Let's say look at it generally speaking. What would Trudeau think of it today? Do you have any idea? Would he be proud of the way it's being used? Would he be frustrated with the way it's being used? Have you any clue?
I actually talked to him about that before he died, and
Yeah.
he was proud of it. But he didn't single out any particular decision.
Nothing?
Yeah.
Oh, okay, because, yeah. But he didn't get into what might make him more frustrated, but
No.
do you think so? You think still today would he be proud of it?
I think anybody would be proud of it. You take a democracy that functions on custom, and functioned very badly on custom, and on the idea that the government would not trample on individual rights. And we pretended they didn't, but the truth was they always did. And they got away with it because there was nothing to stop them. So this is a major achievement, and I'm proud of it.